Good morning, everybody.
Good morning.
Good morning, Lordship.
Good morning.
Good morning, Lordship.
May I mention one?
Yes, who wants to mention?
My lord. I have filed one IA, my lord, for extension of provisional bail, which is going to expire on 18th, my lord.
No, that
Your
is a
lordship
tied up.
Yes, right. With Honorable Mr. Justice Dhengra.
Slip. Please send your slip to the court master.
Yes, my lord. I will send to both the lordships.
Very, very well.
My lord, may I mention a case, your lordship, subject to your lordship's pleasure, your lordship?
Are you again going to ask time in that matter?
My lord, he is not well, your lordship. Only your lordship, he has requested to make a request to your lordship to hear this matter in physical court, your lordship. He has some problem and he is also suffering from cold and fever from Sunday, your lordship. So only he has requested to make a prayer, your lordship, before your lordship, subject to your lordship's convenience.
Very well. Item 12, Mr. Piparwal has praised for learned counsel for petitioner, praised for time as
Mr. Sudhir Sahay, your lordship.
reached the highest. When arguing counsel is not well. So, as prayed for, list the case on Tuesday.
My lord, my lord.
Tuesday.
Oblige, your lordship. Oblige, your lordship.
Subject to Maharaj's permission, may I mention a matter from the list, Maharaj? Supplementary list. Maharaj, serial number 7 appearing in supplementary list, contempt civil 789 of 19. This has become infructuous.
Mr. Mukul Putari, learned counsel for the petitioner, submits that the instant contempt petition has become infructuous. The order has been complied.
Yes, your lordship. I am proceeding this matter, your lordship. The order has been complied, your lordship.
Mr. Gaurav Raj, AC to AG2,
Yes, your lordship.
also submits that the order has been complied. As such, the instant petition is disposed of.
Much obliged.
Oblige, your lordship.
Item 3 not before me कर दीजिएगा और बाकी सब रेफर टू लोक अदालत कल कर दीजिए.
Item 1, contempt civil 870 2018. Mr. Kanti Kumar हो गया.
2 and 3 दोनों को करना है. 2 and 3 not before me and rest refer to लोक अदालत.
Malak, serial number 5 and 8, I may be permitted to withdraw.
That's good. 5 and 8, who is appearing? Mr.
Malak,
Devashi Mandal.
yes,
For the order complied
yes, Malak, order has been.
in both.
Date in serial number 5. It has
Send
been complied.
Send your appearance. Same order in item 5 and 8, except in change in name of the learned counsels. For petitioner, Mr. Devashi Mandal, and for the other side, Mr. Karan Shahdev. You are with?
Serial number 5, your lordship. SC2.
No, you are with
Pending
SC2.
counsel.
And who item 8? State Council in item 8 may also give his appearance. Yes.
So my name, my lord, the first item, my lord, that is first item.
These are being referred to Lok Adalat.
Obliged.
Your Lordship, in serial number 9, Your Lordship, the order has been complied, Your Lordship. I am for the petitioner.
I am for state nurse. Mines.
Mr. Gaurav Raj, you are speaking.
Yes, Your Lordship.
So, same order in item 9, and for the state, Mr. Ashwar Prakash. AC2,
Yes, ma'am. 80 mines 1.
SC minus
Obliged, Your Lordship.
1. Rest matters referred to local.
Under the heading for order, we declare item 1, LP number 664 of 2019, Mr. Subham Mishra for the appeal.
Mr. Gaurav Raj, from your office, Mr. Gaurav Raj, Mr. Subham Mishra. Who is the counsel for state in this first matter? Mr. Prabhat Kumar Sinha, you are also a state counsel.
Unmute करें.
Resigned. Achha, Mr. Rahul Sabu.
My lords.
So he is appearing in. Who is appearing in item 1?
My lords, I'll just, my lords.
What you do, we will grant 1 week time after reopening of holy holiday. You apprise the council, Advocate General's office.
My lords, I will apprise, my lords. I will apprise.
Then counsel for the state, appellant state is allowed 1 week time after reopening of holy holidays to remove the following surviving defects of his two.
Your Lordship, serial number 4 and 6
Same,
of supplementary list.
same prayer is for item number 2, Your Lordship, for removing defect, Your Lordship. Same prayer.
Same order. Mr. Who is appearing? Mr. Omkarnath.
Lordship, in this matter, I am appearing on behalf of.
Very well. Give your appearance to the court master. Sneha Kumari, you are to withdraw contempt this item 4 and 6.
No, Your Lordship. The last order has not been complied, Your Lordship. Therefore, this may remain in bench.
No, let it go to Lok Adalat. If it is not complied or is not settled, then it will come back to bench.
Oblige, Your Lordship.
Item 3, WPT number 553 of 2021, Mr. Anish Kumar Mishra for the police.
Lords, I am appearing for the petitioner in this case, my lord. Lords, the defects pointed out by the stamp reporter has been removed, but still it appears that there are some defects there.
4, 5 and 6. The office notice of 7th March.
Plus, so far as the defect number 4 is concerned, we have filed the certified copy of Annexes 7 and 8. But
you have filed something on 7th March that has not been reported fresh. So we will give time to the office to verify whether defects.
Lordship, may I make a request in this case?
My senior friend, Mr. Gopal Mundra, will be assisted in this case, my lord.
Yes.
Lordship, may I make a request in this case? Lordship, identical issue for the previous financial year 15-16. We filed a writ petition. It has been admitted, and there is a stay on the recovery pursuant to the notice of demand in the assessment order. Lordship, these defects will clarify if at all there is anything, and will the only request which I am making, my lord, since already there is a writ petition filed, admitted, and the stay has been granted, because I am having the apprehension that some precipitative action may be taken by the department, Lordship. That's my only concern.
That writ petition relates to which year and when it has been admitted, and when
Lordship,
stay has
in my
been
writ petition itself, page number 153, Lordship.
You can just orally state also.
Writ petition number 3647, Lordship, of 2016.
That's the 2016 matter. We will apply our mind. Let the defects be removed. If you want an early date, we can keep it on Tuesday, but defects
Lordship,
have to be removed.
I'll be obliged if it can be kept on Tuesday, Lordship.
But that's a physical hearing day. So if you want to appear virtually, then you may not. You will have to. I mean, it may not be possible. You'll have to come virtually.
So, Lordship, whenever the next date when the virtual mode is operational, Lordship.
Could be on 23rd, as per the present arrangement. 23rd of March.
Lordship, grateful.
Very good. Then counsel for the petitioner, Mr. Anish Mishra. Sorry, Mr. Gopal Mundra, assisted by Mr. Anish Mishra, advocate on record, submits that surviving defects number 4, 5, and 6 as per stamp report dated 25th December 2021 have been removed by adequate filing on 7th of March 2022. Stop. Office to verify. Stop. Then counsel for the petitioners pray that the matter may be listed on an early date, as there are likely as similar issues as earlier writ petition involving similar issue of the petitioner has been admitted for hearing with interim protection. Stop. Petitioner apprehends coercive action in respect of the present subject matter by the respondents. As prayed for, list the case on 23rd March 2022 under appropriate heading.
My lord, in this case, my lord, Mr. Ashok Kumar Yadav's name appears on the respondent side, my lord, but this file has been transferred to Manoj Kumar GA3 because the petition has been filed from Mr. Yadav's office.
How do we know all this internal arrangement?
My lord, Mr. Manoj Kumar was instructed to appear today, my lord, GA3, because this file has been transferred.
So ask him to appear and.
Yes, Lordship. We are assigned to Lordship this matter, Lordship, yesterday.
Why do you keep your screen shut and do not submit or make your submissions when the case is called out?
Lordship.
On your behalf, the other responsible AC2 GA1 has made this point. Mr. Manoj, number 3.
GA3, Lordship.
Learned GA3 now appears for the state. Let it be reflected in the context in place of GA1.
Immensely grateful, Lordship.
Who is for petitioner?
Yes, my lords. My lords, this is serial number 4, my lords.
Yes.
Lords, I'm appearing for the petitioner in this matter, my lords.
Your this camera is not properly adjusted. We are not able to see you properly.
Lords, am I visible now?
So slightly on the right side or left, you have to.
Lords, actually, I'm.
The principle of lateral inversion. If those who have studied physics.
Now, is it visible, my lords?
Camera would be moved to the left, then you will be seen more. As per. Yes.
Lords, this is a matter wherein. Please, my lords.
Yes, counsel. There are certain.
Lords, this is a matter where. Yes, my lords. My lords, there is a defect pertaining to the typed copies, my lords.
There are two defects. One is part defect number 9 and the other is defect number 10. Certain typed copy of pages.
Yes, my lords. My lords, we'll get it resolved, my lords. My lords may have it next week or week thereafter, my lords. It's a very short issue. It's a very short
Yes,
issue, my
yes.
lords.
But we haven't gone through because it's a defective matter.
I understand, my lords.
If the defect by tomorrow,
My AR is there. We'll resolve it by tomorrow.
where is
Your Lordship,
the
1 week time may be given.
Why don't you come on the screen when your matter is being called out? This effectively means that you are not appearing before the court if your screen is off. And just to jut in when the order is being passed or after the order is being passed. You should have introduced your senior first, that he would be appearing for the petitioner and you are assisting.
So I apologize, Your Lordship. I'll do from next time.
This Jharkhand only or from some other state?
He is appearing from Gujarat High Court.
But I'm from.
Okay. It's a courtesy to introduce learned senior counsels who are appearing from outstation. Mr. Avinash Puddar, learned counsel for the petitioner, assisted by Mr. Rahul Dev, advocate on record, submit that the surviving defect as under would be removed by tomorrow by filing the relevant copies of fair legible copies of typed copies of the relevant pages. Stop. How they pray for an early date office to verify if the defects are removed as under kar dijiyega dono defect. If the defects are removed, matter will be listed on Tuesday. But Tuesday you won't be able to appear because that's a physical day.
Your Lordship, any physical date, Your Lordship, 23rd of March, Your Lordship. It will be
Virtual day.
virtual day, Your Lordship.
Hello,
We can have this hybrid, then councils can appear on all days.
23rd, Your Lordship, may be posted, Your Lordship.
Just you see, wait for a while, say half an hour. I'm just trying to find out if this hybrid can be worked out from the next week itself. In that case, you can have a date in the next week, Monday, Tuesday, or otherwise we'll give it on 23rd.
Much obliged.
Obliged.
Item 5. WPT number 985 of 2022, Mr. Nitin Kumar Kosari for the petitioner. Mr. Rahul from.
May it please your lordship.
Yes.
But in this case also, the order is passed under 73 and bank account is attached. It is setting the garnishee proceeding without issuance of supervised notice. My lord, kindly see page 94.
Mr. Kurni, this is a defective matter and there are 4 defects which are pointed out.
May I just clarify, This petition was filed online and the stamp reporting was done on 3rd of March. Thereafter, the hard copies have been filed defect-free, minutes.
So the office doesn't differentiate. They have pointed out 4 defects, and it is not clear whether in the hard copy these defects are not there.
Minutes, the reporting was done on 3rd of March.
And hard copy has been filed on?
On 5th of March, minutes. No, 5th of March, minutes.
So then let them say so, no? Let them.
Because once the acknowledgement number is given, thereafter only we can file the hard copies.
True, but are you aware of these 4 defects which have been pointed out?
Yes, minutes.
Page 74 has not been arranged properly. Annexure number will be certified to be 2 copies. Let the office do this checking.
And all the annexure will be certified.
You can have it Monday or any other day.
My lord, my bank account is already attached, my lord.
So then there is nothing else to be done. We will have to only give a protection.
My lord.
If MFS is satisfied.
My lord, kindly see, my lord.
But
have
Mr.
started
Kurmi, let the defects be removed. As in the other 2 previous cases also, our stand or view should be consistent.
Well, there are no defects in the hard copy which has been filed. So because the reporting has been done from the web copy, the online filing copy, that is why these defects are there. Otherwise, we have filed the physical copy, there are no defects.
We will record your statement, but this fact has to be verified and reported by the office.
Yes.
So whatever you suggest, Monday, Tuesday is there, but let me ask this.
Monday. नेक्स्ट इवेंट डे होगा जो उसको करते हैं, कोई दिक्कत नहीं. नेक्स्ट वर्किंग डे जो होगा नहीं तो हाइब्रिड में कर सकते हैं. क्या कर सकते हैं, पूरा खाली है.
can keep it on Tuesday. Let's see if it starts working in a hybrid mode, then Mr. Kurmi can.
My lord.
The Mr. Prashari, Learned Counsel, Mr. Karthik Kurmi, Learned Counsel appearing with Mr. Nipun Kumar Prasari, Advocate on record, submits that defects have been removed in the hard copy, which has been filed on 5th of March.
Yes, Manoj. 5th of March.
Defects, as indicated by the stamp reporter as under, have been removed by filing in the hard copy filed on 5th of March 2022. Office to verify. Stop. And counsel for the petitioner submit that the matter was taken up on an early date, since the bank account of the petitioner has been attached, and that too in the closing month of the present financial year. Stop. As paid for, list the case on 15th of March 2000. Or we can keep it on Monday also.
Monday also not difficulty, my lord.
In that case, because Tuesday, last day before holiday, sometimes get affected.
Yes, my lord.
Holy mood.
My lord. Deeply obliged, my lord. Deeply obliged.
तो फिर उसमें 23rd ही रखते। Item 4 who was appearing? Rahul. Mr. Rahul Dev.
Because I was appearing with the respondents.
So I think he has left.
That
He has left the Milord chat room, Milords.
no, maybe, but we can keep it on Monday, subject to the hybrid mode started functioning. Otherwise, it will go to 23rd if he still wants an adjournment. Just ask him to convey to the court master, whichever date. Because today it is unsure. Mr. Prasari has taken a risk that he may argue on his own on that day physically also.
Prince, I'm much more happy because 15th, me and my associate Siddhi would not be in town. We would be before Lucknow bench minutes.
I thought you would be going for a holiday. Then we would have restrained you from going before the court. Very well, then 23rd kar diye. The court master says that he has indicated that it should be item 4 on 23rd March.
Okay. Item 6, Article number 27 of 2018, Mr. Manoj Kumar number 4, for the appellant. Mr. Lalit Yadav, for the
Lordship, I appear on behalf of the appellants, my lord. I filed the substitution petition, Lordship.
When?
Lordship, फाइल 7 मार्च को कर दिए हैं, Lordship.
Mr. Manoj Kumar number 4, Land Counsel for the appellant submits that interlocutory application bearing number?
Number, Lordship, तो नहीं मिला है, Lordship.
Has been filed on 7th March 2022 for substitution of the deceased respondent number 5. Let it be placed on record. The matter should appear in the week of 21st. Our matter should appear on Monday. Monday, 14th March. अभी फाइल नहीं हुई है. Mr. Lalit Yadav, tell him that IA has not been filed.
Though he has served a copy, it may be dropped on the box, my lord. That's why token could not have been generated till it. That would be the difficulty.
After holiday.
Though I will inform him, my lord.
Very well.
Obliged.
Item 7, Review number 53 of 2019, Mr. Vice Tiwari, for the
It was filed on the same address where from Mukul for
पेपर पब्लिकेशन तो भी नहीं किया है।
नहीं किया नहीं है, हम बोल रहे हैं न्यू ऑफिस में
वो
जो
तो
फ्रेश स्टेप लिया सेम कर
Mr. Tiwari, the report, service report says that it has returned because the respondent doesn't stay at the same address.
Yes, Your
The
Lordship.
press record, same address was given. Why the same address was given when it was indicated in the order of 18 January 2020 that present and correct address should be given?
Yes, Your Lordship, but save and accept that address, we do not have any other address, Your Lordship.
You should have said that.
And Your Lordship, she has filed a contempt. In the contempt also, the same address has been given by her. Contempt ka number kya?
No, if she has filed a contempt and the contempt is pending, is it pending?
Yes, Your Lordship.
Then you ask the counsel who is appearing for her in the contempt to join the proceedings today. We can ask him to appear in this case. Who is appearing for her in the contempt matter?
Mr. P.K. Verma.
To ask him to join, you can contact, your office can contact him, ask him to join anytime before lunch. We can inquire from him that whether he can seek instruction to appear in this matter also. Otherwise, it is the railways who is the petitioner, so nobody would care to get the present address, and this file would be going in circle on the issue of service of notice only.
I was only praying Your Lordship may fix it tomorrow so that we can get a chance to talk to Mr. Verma. Because today...
Monday.
Yes, Your Lordship.
Give the contempt number.
Contempt number kya hai?
187.
Huh?
187 of 90.
It is, Your Lordship, 187 of 2019.
When counsel for the petitioner, Mr. Mahesh Tiwari, submits that the opposite party has preferred a contempt case civil number 187 of 2019 against the judgment being sought to be reviewed. Stop. However, notice is being returned in view of the service report that she doesn't reside at the address which is mentioned in the contempt petition also filed by her, and also in the in the writ petition from which the review arises. Stop. He, however, prays that the matter may come up on Monday so that the learned counsel appearing for her in the contempt matter can be informed to join the proceedings of the court in this matter on the next date. Mr. P.K. Verma. List it on, accordingly list it on 14th March. ये कंटेम्प्ट में भी हम लोग का टाइड अप है कि सिंगल में हुई तो फिर ऐसा करिए let contempt civil case number 187 of 2019 be also listed on the next date along with this review petition. Monday, yes.
Topic number 296 of 2019, Mr. Pradeep Kumar Ganguly for the Mr. Amit Kumar Sinha for the
May it please your lordships. My lords, I was praying that this matter may come after holy vacation, my lords, because the petitioner wants to settle the matter with the respondent, and he is likely to talk to her at local level.
You are for appellant?
Yes, my lords, I am for the appellant husband.
Mr. Pradeep Kumar, and counsel for the appellant submit that there are talks of out-of-court settlement going on between the parties. Stop there.
Not going on, my lords. He will talk to them.
That the appellant is making endeavors for out-of-court settlement
Yes.
with the opposite, with the respondent wife. Stop. As such, the matter may be adjourned for 2 weeks, 3 weeks.
Much obliged.
Lordship, I am appearing on behalf of the respondent, Lordship. Wife.
Mr. Raj Sharma, for list it up. 3 weeks.
Much obliged.
Item 9, LP number 647 of 2019, Mr. Rohit Sinha for the appellant, Mr. Ajit Kumar for the
My lord, this is IA for limitation. IA number 511/2020. The delay of 103 days. The appellant, Lord, he was ill, that we have explained. We have given the medical certificate also. And that's why he could not refer in time. In para 4 and 5, where is explained. Yes, my lord, I appear on behalf of the appellant.
State. State.
Oh, state.
For the state, who is appearing?
Yes, Lordship, in serial number 9, I am appearing for the state, Lordship.
You oppose the prayer for condonation of delay? Yes, Mr. Sushant, do you oppose the prayer?
Mic on.
No, Lordship, no. I do not oppose.
Rajiv Sinha and learned counsel for the state, Mr. Sushant Kumar, AC2 AG.
Yes, Lordship, Mr. Prince Chitresh is appearing in this matter, Lordship.
Who is appearing? किनके तरफ से आप अपील कर रहे हैं?
स्टेट की तरफ से लॉर्डशिप, मतलब ये पे हम अपोज नहीं कर रहे लॉर्डशिप.
Which state council or administrator?
Lordship, cannot. Lordship, I will be reconnecting.
Who is your senior? Advocate General's office or?
Advocate General Office, Lordship. Mr. Learned Senior Counsel, Mr. Rajiv Ranjan.
Okay. On the prayer for condonation of delay of 103 days in preparing the instant memo of appeal, the appellant counsel for the appellant submits that the appellant was suffering from various ailments and was bedridden from second week of June 2019, due to which necessary steps could not be taken within time for preferring the appeal. Stop. However, appellant will suffer irreparably if the delay is not condoned, since he has good grounds on merits. And counsel for the state not have serious objection to the prayer. where we have considered the submission of learned counsel for the parties and taken note of the grounds urged. It appears that petitioner, appellant, was suffering for some ailment, being aged person was suffering from ailment, and there is some delay in instructing the counsel, his counsel for preferring this appeal within time. Medical prescriptions have been enclosed to the IA. On consideration of the explanation and the submission of the parties, delay is condoned. IA stands disposed of. He will be listed under the heading for admission.
May I make a prayer, my lord, if it may be listed after the holy vacation?
After the holy vacation.
Obliged.
Obliged, Lord.
Item number 3, first appeal number 17 of 2020. Mr. Ashutosh Anand for the appeal, Mr. Sandeep Kumar Pandya for the.
I am for the appellant, Your Lordship. Lordship, the respondent wife has appeared.
I am appearing on behalf of the respondent, Lord.
So, both of you joined the mediation?
Yes, my Lord.
Yes.
Respondent has entered appearance on notice through Wakalatnama. The learned counsel for both the parties proposed that the matter may be referred for mediation at Jhalsa so that an amicable settlement of the matrimonial dispute between the parties can be found out, can be arrived at. Stop. Considering the submission of, on consideration of the proposal of the parties, which is in line with the spirit, aims and object of the Family Courts Act 1984, parties are directed to appear before the Learned Member Secretary Jhalsa on 21st March 2022. 21st March?
Yes, my lord.
Yes, my lord. 10:30 a.m. Learned Member Secretary can also be approached on the following numbers. Upon their appearance, matter be placed before the learned mediator for undertaking the exercise. Appellant shall pay a sum of rupees 1,250 to the respondent on each date she attends the mediation proceedings, in presence of learned mediator Jhalsa. Stop. Parties should cooperate in the mediation proceedings with an open mind and attend each of the sittings. If they are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report. 4 weeks thereafter. That will be listed in the week of 1st May 2022. Sorry, 2nd May 2022. Along with the report.
Obliged, Your Lordship.
Obliged, Your Lord.
Yes.
For admission, item 11, WPS number 1546 of 2017. Mr. Saral for the petitioner, Mr. Rajeev.
In this case, I have filed my counter affidavit, my lord, last week.
My lord, I am applying for the petition. When have you filed, Mr. Prabhat?
My lord, on 2nd of March, my lord.
On 2nd of March? the counter affidavit could not be placed till today. It's almost 1 week.
Lord, we are facing, my lord, after 6-7 days, we are getting token numbers, my lord.
When counsel for the respondent BSNL submits the counter affidavit. So it is not on record, so we will keep it on some other day. You do not want to file any joinder?
No, my lord. I have received the counter affidavit. Same statement has been given, which has been given before the learned cat, my lord.
Yes, my lord, our stand is, my lord, in the counter.
Don't talk about your stand. That is not before us.
Yes, ma'am.
Otherwise, you would have disposed it of today.
Yes, my lord.
Prabhat Kumar Sinha and counsel for the BSNL submits that counter affidavit has been filed 2nd of March 2022. Stop. The institution entry in the computer shows that it has been instituted on 5th of March 2022. Stop. We fail to understand as to why the counter affidavit could not be placed by the concerned writ section till date. So the list was prepared on Monday. Stop. Let the matter be inquired into by the Joint Registrar Judicial and be reported to the court. Stop. Let counsel for the petitioner submits that no reply need be filed. Stop. As such, matter can be listed on Tuesday, 15th March.
Yes.
Yes, yes. Obliged.
Item 30, WPS number 4944 of 2017, written Mukesh Kumar Mehta for the petitioner, Mr. Gautam Rakesh, Mr. Vijay Kumar Sinha for the
Anyone appearing? Who is appearing?
Your Lordship, I am appearing serial number 13, Your Lordship.
For petitioner?
Yes, Your Lordship. Your Lordship, I'll seek time and file rejoinder, Your Lordship, in this case.
This petition was earlier dismissed for default and then restored. and the counter affidavit is of 9th August 2019. And when now it has been taken up, writ petition is of 2017. You are again asking for time.
Your Lordship, happen is the main counsel is not here, so Your Lordship, I was and the instruction was to file rejoinder in this case, Your Lordship. In this case, two main counsel were there. They got in judicial service, so only one counsel is left, Mukesh Kumar Mehta. Another one is Oath Commissioner. So that is why there was default, and then.
So now you are appearing. You are appearing with which counsel on record?
Mukesh Kumar Mehta.
Why is Mr. Mukesh Kumar Mehta not appearing?
He could not come, Your Lordship. He was in Dalton, Your Lordship.
That's not at all an excuse.
Yeah.
That is not at all an excuse. You better argue. We have gone through the file.
Your Lordship, I will not be able to argue, Your Lordship.
So then we'll dismiss it for non-prosecution as not pressed.
Kindly give us, otherwise I will take a very short time, Your Lordship. Kindly grant some short time, Your Lordship.
You prepare yourself, we will keep it in the second half.
Very short time. Tomorrow maybe, Your Lordship. I'll read the file, I'll get the file and
you will have to argue.
I'll argue tomorrow, Your Lordship.
Learned Counsel Mr. Prem Madhi seeks short time to come fully prepared. Seeks 1 day's indulgence to come fully prepared. Now, anyone appearing for the respondent? Anyone appearing for the respondent in item 13? Next the case tomorrow. Stop. However, no further adjournment would be granted. The petition relates to the year 2017 and was earlier dismissed and was earlier restored after being dismissed for default.
Item 14, WPS number 7311 of 2019, Mr. Sasi Kumar Verma for the police matter.
Who is appearing?
Sir, I am appearing on behalf of the petitioner.
Yes. What's your case?
Lordship, last day, it is taking time, Lordship, for file. You are the defendant. Last date, Lordship. Last 22 to Koya by Lordship. Alright.
We are not able to understand. You argue your case?
I am the petitioner, Lordship. Two cases in clocks, Lordship, 35, Lordship.
Is that matter?
That matter.
Where is the state council?
Something by star reporting not restored.
ये तो कब रेस्टोर हुआ है? Last Wednesday हुआ.
Last Wednesday तो 2 तारीख 7-3
इस वीक में तो नहीं हुआ. नहीं होता. होंगे। Petition में defect होता है, इसके लिए you can merge to last Wednesday. Writ petition service number 3515 of 2019 has been restored by order dated 2nd March 2022, passed by a coordinate bench of which one of us, within bracket of Kumar Singh J, was a member. Stop. However, the same has not been placed along with the present petition. Stop. Office is directed to place WPS number 3515 of 2019 along with the instant case. Stopped. Matter be listed on 24th March 2022. Petitioner Mr. Shashi Kumar Verma. Yes.
WPS number 2547 of 2020, Mr. Piyush Kumar, or
15, 16 and 17 all relate
All
to
are similar
virus.
in all are similar in nature, my lord. And so far as virus of the act is concerned, we are not pressing that one, my lord, because of the reason that at the time of filing of the writ petition, my lord, there was no time limit so far as the section 140 of the act is concerned. And the department has by rules 117 the time limit was fixed, my lord. On that ground, we had challenged the virus of the rule 117, my lord. Now we are not pressing because it has been amended, my lord.
So you are not pressing prayer number 1A and B.
Yes, my lord. Because subsequently it was amended, my lord, and the time limit has been prescribed in the section itself, my lord. And therefore we are only challenging the annexure 8, my lord, by which our application for TRAN 1 was rejected by the authority concerned, my lord, on the ground that there is no provision for filing manual application, my lord. And due to technical glitch, we could not file the TRAN 1 online, my lord.
So what was the last extended date, Mr. Mittal?
Malaj, it was till 30th June 2020, Malaj. 30th June 2020. The best of my knowledge, Malaj, was 30th June 2020.
TRAN 1 had been filed before that date.
Yes, it was filed before that date, my lord. It was filed on several dates, my lord. We have tried on several dates, my lord.
Malaj, at least in serial number 16, there is no evidence of filing. They have just stated in para 18 that it was filed on 13, 16, 19 and 30th December. But there is no screenshot. At least there had to be a screenshot to show that they filed. They've admitted that they've not taken a screenshot.
My lord, may kindly peruse page 102, my lord, annexure 8, my lord. The last page of the writ petition, my lord. This is 1st July 2020, my lord. May I read, my lord? व्यवसायी द्वारा ऑफलाइन ट्रान 1 दाखिल करने के लिए एक आवेदन दिया गया है अपने आवेदन में माननीय दिल्ली उच्च न्यायालय के सचिन सच में पारित न्याय निर्णय का उल्लेख किया गया है, जबकि झारखंड वस्तु एवं सेवा अधिनियम 2017 की धारा 140 रूल 117 स्पष्ट प्रावधान है कि व्यवसायी को निर्धारित सीमा के अंदर टैन 1 और जीएसटी ऑनलाइन दाखिल करना है, परंतु व्यवसायी द्वारा ऑनलाइन टैन 1 दाखिल नहीं किया गया, न ही जीएसटी काउंसिल द्वारा ऐसा कोई आदेश प्राप्त है कि टैन 1 से संबंधित विवरणी ऑफलाइन स्वीकार करना, तो व्यवसायी का इस आवेदन को अस्वीकृत किया जाता है. So that was the order, my lord. And so recently, my lord, the Honorable Odisha High Court has that has been reported in 2021 133 taxman, my lord, 256, my lord. I am reading the last paragraph, my lord.
2021
133 taxman.com 256 Odisha, my lord. This is order dated 16 September 2021, my lord.
Have you sent the judgment?
No, my lord, it has just I have get out this order, my lord. I'm just reading 4 line, only the conclusion portion I'm reading, my lord. May I permit it to read? May I read, my lord?
Read out. We thought that it's a virus, so it will go before another bench. Now you are saying
Yeah,
that
I'm not challenging the
not
virus,
want
my lord. We are not challenging.
You file an affidavit.
Yes, my lord. Yes, my lord.
I will
file IA
application.
Yes, my lord.
So all 15, 16 and 17 can be tagged together?
Yes, my lord.
Let WPT 2560 of 2020 and 2564 of 2020 be tagged together with the instant petition since common issues are involved in all these writ petitions relating to the acceptance of delayed filing of TRAN 1. So, then counsel for the petitioner submits that prayers are identical in all the writ petitions except the difference in the individual facts.
Yes.
So, he further submits that he would not be pressing. Petitioner doesn't want to press the prayer relating to the virus of the Rule 117 of the JGST Rules 2017. Stop. When counsel submits that he would be filing an interlocutory application to that effect. Stop.
सुप्रीम कोर्ट का जजमेंट से कवर हो गया 20 जून को 20 मार्च को लॉकडाउन था 28 फरवरी तक लॉकडाउन था मैंने वो लिमिटेशन जजमेंट अगर दे देता ट्रांसफर रिलीफ कर सकते हैं.
So, how much time do you require to file?
Within 2 weeks, my lord.
He undertakes to file interlocutory application to that effect within 2 weeks. Stop. You don't have any screenshot of your filing to support the statement made in the writ petition?
No, my lord, I haven't seen, my lord.
Accordingly, list these cases after. Counter has been filed.
Yes, my lord, counter has been filed.
Yes, Your Lordship, counter has been filed.
On behalf of state, but not on behalf of
GSTN has not filed, my lord.
GSTN has not filed, my lord.
So he is not annexing any screenshot. So how GSTN will respond to that?
Yes, my lord.
Yes.
It's a question of pure delayed filing, not on account of the technical.
Yes, yes.
List the case after 2 weeks. These cases.
Obliged.
Give your appearance respected.
Yes, my lord.
3 weeks. List after 3 weeks.
Item item 18, TA number 15 of 2021, which item?
May I
This
please,
you
Your
will
Lordship?
be discussion about tax effect or
No, Your Lordship, I will be filing an affidavit with respect to the tax effect, Your Lordship, examining all the exception clauses also as indicated by Your Lordship in the earlier matters. This is the same matter, interest under 234 AB.
then counsel for the appellant, Ms. Amrita Sinha, prays for 2 weeks' time to file affidavit uh, with regard to maintainability of the appeal on the question of monetary limit and if and whether it falls within any of the exceptions of the CBDT circular. As prayed for, list the case after 2 weeks.
Much obliged, Your Lordship.
List the case in the week of 28th March 2020. Item 20 or a call for legal.
Item 20, appeal number 64 of 2021, Mr. Sakat Iqbal for the
May it please, my lord. I am appearing on behalf of the appellant, my lord. My lord, am I audible?
You're not visible. First be visible and
Well, just give me 2 minutes. My camera is not working. 2 minutes, my lord. My lord, am I?
कॉम्पिटेंसी अपना शो करो यस शौकत इकबाल साहब का रेगुलर नोटिस जाएगा वैसे they have a period.
yes, Mr. Iqbal, you're taking too much time to come on this.
I'm sorry, my lord.
You should have
Am I audible now, my lord?
corrected your settings before the court starts.
My lord, I was
Issue,
prior to this. I'm sorry, my lord.
issue notice on the respondent under registered cover with ATs and speed post for which requisites be filed by 15th March.
My lord, they may, if the courts are open on 14 and 15, there is a rumor that it may close. I'm sorry. But if your lordship may permit, by 23rd, I'll do the same.
23rd March 2022. Failing which this appeal and dismissal of
My lord, in interim, my lord, because they have also filed a section 24 petition, my lord. My lord.
Not
notice.
Oblige, my lord.
yes, item 19.
Lordship, I am appearing Lordship 19, Lordship.
item 19, LP number 31 of 2021, Mr. Shankar Lal Agarwal for the Mr. Rajiv, Mr. Sachin Kumar for the
This also appears to be like a similar case as perhaps yesterday in which you were appearing. That
No, Lordship.
writ petition was withdrawn because of an undertaking and some amounts have been paid. Now the petitioner is disputing that he is not liable to pay the remaining.
No, Lordship. No, I'm not disputing, Lordship. My case was that an agreement was executed between the board and the appellant regarding payment of such an amount, Lordship. That since that agreement was not part and parcel of the writ petition, the learned single judge observed that since you have not annexed the agreement, though I prayed for adjournment, that is agreement is now in my possession. I want to file that agreement, but in spite of that, my writ petition was dismissed without giving me any opportunity to bring that notice before my lordship. This was, if my lord permit me, I can read the portion of that order passed by the learned single judge. This is I'm not disputing, lordship. That amount has been paid. Apart from that amount, extra amount is being asked by the board lordship. In view of the agreement arrived between the board and the appellant lordship, I have next the copy of the agreement. Since the agreement was not before the honorable court lordship, therefore that order was passed. I am not going beyond my pleadings, lordship. Whatever had happened, I am pursuant to the lordship agreement. Kindly see, lordship.
Counsel, where are the respondents' counsel? It's a matter with the JBBNL. State is hardly involved in it, except that the certificate proceeding was instituted. JUVNL, who appears?
Mr. Rajiv Ranjan's name is coming in the list, Your Lordship. I am for the state, Your Lordship.
A counter was filed in every application.
You, Mr. Gaurav Raj, you are appearing in this matter or you are just apprising us as to who is appearing for the state?
I am for the state, Your Lordship, in this matter. On behalf of Mr. Sachin Kumar, Your Lordship.
The Advocate General's names will appear only if he represents the state, not for the JUVNL. So, whether Mr. Rajiv Ranjan is appearing for JUVNL or not in this case.
This matter has been allotted to us on behalf of the state, Your Lordship, not on behalf of JPBNL.
That we have understood. We are asking who is appearing for JUVNL. Mr. Shankarlal Agarwal, don't go out of the screen. और आप थोड़ा अपना कैमरा भी एडजस्ट करिए. आपका your complete face is also not properly visible. कैमरा नीचे करिए. tutorial.
Whether counter was filed in the writ application?
Mr. Agarwal?
Lordship.
Brother is asking whether counter affidavit was filed by
yes,
the
Lordship,
JUVNL.
filed when counter was filed in writ petition, Lordship.
Then why did you not bring the agreement on record earlier at
Lordship, at that time, Lordship, agreement was misplaced. There are a lot of litigation between this board and this appellant, Lordship. So somewhere it was lost, Lordship. When this was pointed out, then I asked my client, where is the agreement? Kind of search it out. Then it was made available to me, Lordship. Otherwise, there was no intention to conceal this fact. That was the seat anchor of this case, Lordship.
So basically, what is your grievance now? You have paid rupees 5,04,543 perhaps.
Pursuant that agreement, Lordship.
That agreement, no. This agreement of 31st December 2005.
Lordship.
Pursuant to this agreement, you paid 5,04,000.
Lordship.
Then where is the dispute? What is pinching?
this was Lordship, agreement had arrived between the board and the petitioner. It was agreed that regarding the matter of fuel surcharge, it shall be kept in abeyance till the disposal of the Supreme Court case, and you pay the charges regarding this 5 lakhs and odd. And this kindly see the agreement, and I am only relying upon the agreement, whatever the amount is in the agreement. But regarding other amount, Lordship, the matter of fuel surcharge is still pending before this court, Lordship, before division bench, in the case of Usam Martin's case, Lordship. And further my argument was, Lordship, that if any, the amount was barred by limitation, Lordship. That matter was not been gone into by the single judge. For that purpose, Lordship, if my Lord give me permission, I want to bring to the Supreme Court judgments on record, though may go against me, Lordship. But for proper adjudication, Lordship, those two judgments regarding the limitation, Lordship, are much very relevant, Lordship. It may go to against me, Lordship. But the point has to be decided regarding limitation, because certificate case was barred by limitation in total, Lordship. The court has given explanation that since you have admitted in the agreement, so therefore now there is no question of limitation. But the principle of limitation is that once a proceeding is barred by limitation, it cannot be revived by any agreement or by any acknowledgement, Lordship. So I want to bring those two decisions of the apex court regarding the applicability in the electricity matters, Lordship.
You had approached this court in
Lordship.
WPC 021 of 2004
Lordship.
because of the certificate proceedings initiated against you.
Lordship, then, Lordship, if my Lord will see, I was relying on a letter issued by the chief engineer that I will give some relief.
We have not completed our sentence. Please listen
Lord,
to us.
I beg apology, Lord. I beg apology, Lordship.
You had approached this court in 2004, being agreed by the demand raised in a certificate proceeding in respect of your unit, which was disconnected. Electricity was disconnected from December 1999 itself.
Lordship.
Now, during pendency of that writ petition, there was some exchange between the parties, and on some understanding, petitioner's counsel withdrew the writ petition as it has become inferiors. The understanding that it appears was arrived at was to the effect that you will pay the admitted amounts of whatever it is as per the undertaking and agreement, and fuel surcharge amount will be kept in abeyance.
Lordship.
Now you have paid 5,04,000. What more is the board asking from you with which you are agreed?
Lordship, regarding the fuel surcharge, Lordship.
Fuel surcharge, when they have agreed not to charge from you, then how can they charge it now? That was kept in abeyance pending the outcome of the litigation.
Lordship, can it may be possible for day, Lordship? I may take instruction from my client, Lordship. Maybe tomorrow, Lordship. Tomorrow, day after tomorrow, Lordship.
Lot of difficulty, Mr. Agarwal. These
Lordship,
days,
I am also
more counsels are not appearing. We are exercising restraint. Otherwise, we can ask the officer to appear. You can see for last 20 minutes, the counsel for the board is not appearing. Name is appearing. You have served copy. Mr. Gaurav Raj, senior, also appears for the board, but he is also not appearing. So this is the state of affairs. We do not want to make more observations which might hurt their professional. Mr. Sachin Kumar has been appearing for JBVNL.
Yesterday I handed over a copy, Lordship. Yesterday I handed over a copy of this petition LPA to Mr. Sachin Kumar also, Lordship.
So that's the difficulty. No? How do we function? When we come to narrow down to a point, then the matter gets adjourned. Either side is seeking adjournment. इसका रिट पिटिशन का फाइल आया है लेकिन
सचिन कुमार क्योंकि इसमें दिए और उसमें दिए उसमें एजी की तरफ से जो यूज कर रहा है
नोटिस कर रहे हैं। Mr. Roy, you are appear in the writ petition for JUVNL. Are you appearing in the appeal also?
My lord, I'll appear, my lord. I'll accept notice, my lord.
We have spent quite 20-25 minutes on this.
Sorry, my lord, I am extremely sorry, my lord. My name did not appear, therefore I could not mark the case.
We are not blaming you. We are just trying to find out upon whom the copy has been served, because name of both Mr. Rajiv Ranjan and Mr. Sachin Kumar are appearing, and they both are state councils and they both are JUVNL councils also perhaps. And we are not able to understand the controversy because the earlier writ petition was withdrawn on some understanding between the petitioner and the board.
Yes, ma'am.
That he will have to pay some amount and fuel surcharge will be kept in abeyance. And now in that writ petition he had challenged the notice of 28 April 2003. Sorry, in that writ petition some order of certificate case must have been challenged. In the present writ petition also the same notice of 28 April 2003 has been challenged, issued in the certificate case. And Mr. Agarwal is also not able to clarify as to what is the grievance of the petitioner. Are you aware of the facts of the case, Mr. Roy?
My lord, can it be tomorrow, my lord? I'll assist your lordship, my lord, in a better manner, my lord, since I am not ready.
So should he serve fresh copies upon you now?
Yes, my lord.
Mr. Agarwal, serve copy of the appeal on Mr. Mrinal Kanti Roy.
Yesterday itself it was served to Mr. Sachin Kumar, Lordship. Well in advance, Lordship.
Then, my lord, we will exchange, my lord. I will take it from Mr. Sachin Kumar. That is the case.
It was served on Mr. Sachin Kumar as AG2 or as counsel for JUVNL?
AG.
So that service won't suffice. You will have to serve separately on the JUVNL council. These are very hackneyed issues. Young startup beginner in the profession need to be told all this. Mr. Agarwal, you serve it upon him tomorrow by 2.
Lordship.
Mr. Shankar Lal Agarwal and counsel for the appellant undertakes to serve copy of the memo of appeal with its annexures on the counsel Mr. M.K. Roy, who appears for the respondent. Now it is board or JUVNL? What?
JUVNL, my lord.
Jharkhand Urja Vitran Nigam Limited.
Vikas Nigam Limited.
विकास निगम लिमिटेड. इसमें तो दोनों को बनाए हुए, झारखंड बिजली वितरण निगम लिमिटेड और फिर झारखंड. Here he has implemented Jharkhand Bijli Vitran Nigam.
Then JBVNL, that it will be JBVNL.
N4 कर देता है। N4 कर देता है।
नहीं, रिट पिटिशन जो डिसाइड हुआ ना, उसमें मिस्टर रॉय यू आर अपियरिंग फॉर JUVNL परहैप्स, कहीं पर, हाँ, JUVNL। तो बेसिकली यू विल बी अपियरिंग फॉर JU और JB
Both manner, both manner.
and find out.
No, both manner.
JUVNL
is
is
the holding
holding
company.
company. JUVNL is holding company, and others are the other companies are subsidiaries.
The other companies have their own set of panels, na? And JUVNL may have a
Panel is common, Milord. Panel is common.
Panel is common.
Online counsel for the JBBNL / JUVNL, Mr. So and so. Stop. Let the case appear after opening of holy holidays.
Deeply obliged.
Now item 22 and 23 are finished. 21 will take. 22 and 23.
Item number 22. WPT number 3094 of 2021 is the Mr. Kumar Patani for the
Merits, I'm appearing for the petitioner in this matter. The pleadings have been completed, Merits.
May I just submit your lordship? On 7th of March, I have received a rejoinder wherein they have taken a specific plea that the assessment is time barred. I have taken an instruction, oral instruction is there that it is the time barring is till 31st of March 2022. So I need to file an affidavit to that, a reply to that extent, your lordship, controverting the stand taken by the petitioner over in the rejoinder. Because the main issue involves in the assessment order, the passing of they are claiming for refund, and we are stating that refund cannot be claimed for the reason that the assessment is still pending. And now that they are saying that the assessment has been time barred for, and therefore we need to file a reply is necessary, your lordship, stating that it is not yet time barred and the time was extended till 31st of March 2022.
Well, to my understanding, the last notification which had come, which I have annexed by way of my rejoinder, that notification has not been overruled. Mills. That is not superseded by any other notification. And that notification was in terms of section 3(1) of the taxation and other laws, relaxation and amendment of certain provisions.
So that
So
purpose
taking into
also
consideration that to be read with section 153(a)(2), Mills, 2A, Mills, nothing survives. It has become time barred on 30th September itself, 30th September 2021. That was the extension which was given. Thereafter, there is no extension.
Why couldn't you take this point in your writ petition?
Mills, because of the fact, Mills, that this amendment was not within my knowledge, Mills. It has come subsequently. This notification, Mills, I was.
Otherwise, the respondents have a valid point that because the ITAT has not determined the tax payable and only remanded it,
Yes,
how can you get the so long the tax is not determined? Now, the other vital issue which you are raising now, that the assessment itself is time barred. In that case, they cannot withhold.
Yes, Mills.
So, Ms. Amrita, you
Mills,
can.
if they want to take, Mills, if they want to take any instruction, Mills, I will not object to that, Mills.
We also need to be satisfied now. If the assessment itself is time barred,
yes, Mills.
And then the remand order is meaningless, and then whatever you have paid, whatever will be the fate of it, will have to be decided by the department. If there is no tax due against you, they will have to refund it.
That is precisely my case, Mills.
So this issue needs to be addressed.
Income Tax Department, Ms. Amrita Sinha submits that such new facts have been brought on record through the counter affidavit
in the
filed
rejoinder.
on.
It's in the rejoinder.
In the rejoinder.
In my counter, I have stated, Your Lordship, that at para 4 that the assessment proceeding is still pending, and to that they have in their rejoinder.
Rejoinder has been filed when?
On
Because it was
7th
filed on
of March.
7th, minutes.
Don't have that on our record. There are two counter affidavits.
No, Your Lordship, one
No,
counter.
one counter.
One email filing and the
Email
other
filing.
hard copy.
Yes.
Rejoinder filed on 7th March 2022. Stop. She submits that now the petitioner has taken a plea that the assessment proceedings upon remand by the ITAT is itself time barred. Time barred when? Which
No, it's
September?
30th September. 30th September 2021.
2021. Stop. I spread for 2 weeks. 2 weeks would suffice.
Yes, Your Lordship.
2 weeks time allowed to and counsel for the respondent to seek instruction and file reply to the rejoinder affidavit. Matter be listed after 3 weeks.
Much obliged, Your Lordship.
That is again, rejoinder is not there in our institution. Institution, it is not there, Mr. Sorry. Check,
No,
check
but
up.
it has been filed physically, minutes in the Dropbox.
Okay, then it will be instituted perhaps today.
Yes, minutes.
WPT number 3174 of 2021 is Vani Kumar, Mr. Vani Kumari for the petitioner. Vani Kumar for the
Yes. Who is appearing?
Lord, item number 23, I am appearing, my lord.
Yes, yes.
Lord, this matter relates to, my lord, a demand confirmed by the Commissioner of Central Excise.
Where is the council record? At least she should be on the screen.
Yes.
Your council on record, Ms. Vani?
Is Vani Tiwari?
Yes, Lordship, I'm present here, Your Lordship.
Okay. So you should
So I'm
introduce the council appearing from outstation.
Lordship, may I submit one thing, Lordship?
Lord.
So just a minute. Let us first know the good name of the learned council.
My lord, my name
Yes,
is
Your Lordship, we have been engaged in this case, Your Lordship.
Madam, my name
Nirmal
is
Kumar Yadav.
Acha. You are assisting from Calcutta?
My lord, yes, I am from Calcutta. My lord, actually I wanted to appear physically, but that could not be accommodated. So I have been compelled to address from here, my lord. This is a covered issue. My lord, if my lord allow me to.
Lordship, may I submit one thing? In this case, Lordship, as per Annexure 5, Lordship, Honorable Justice Deepak Roshan, he has appeared as a senior standing counsel, Lordship.
Page
138, Lordship.
In the tax appeal.
Yes, Lordship.
My lord, departments, my lordship may appear for the department, but not from any party. There cannot be, this cannot be, if that be the position of the department, number of matters, he may be appearing for the department, but not for any other party, not for me.
So, brother, of course, this is a call of the conscience. Brother would not like to hear it. But what was the point? For my interest, I just wanted to know as to
Yes,
how.
my lord, the point is, my lord, that whether the consumption of electricity can be a determining factor for production capacity of production, and on that basis, the demand can be raised.
No, but in that case, if this court in another jurisdiction has passed an order which has become finality.
Yes, my lord. Now, a number of at least dozen of orders. At least a dozen of orders have been passed by this court, and one is Calcutta High Court, and other courts have also done. My lord, on this identical issue.
No. After that order has become finality, or the original OIO has become final pursuant to the.
Yes, my lord. Department has accepted that. Department has accepted that no further appeal has been prepared.
In that case, can it be opened in a writ jurisdiction again? This issue.
My lord, we are on the bona fide belief that no action will be taken. But in this case, my lord, they are proceeding against us for taking coercive steps. Unless we get this order, get any order from the higher authority, then that they will proceed against us.
No, how does the? Sorry, we should not hear it detailed. Let it go before other bench. The only question which was striking to me was how can the writ petition be entertained after the same dispute has become final by virtue of the order passed in the tax appeal?
But in view of the fact that department is not obeying that, the department has been intimated. My lord, in this case, my lord, this court has at least passed a dozen of orders. One of such orders I have annexed in this writ petition, and my lord, in the last annexure I have annexed one writ petition. And my lord, the tribunal has at least 30 matters have been demanded to the Jamshedpur jurisdictional authority and other authorities where from this issue came up from before the tribunal. My lord, this issue could not be was not decided because and one order original was passed, and that's why my lord I have been constrained to come up before this court, my lord. But this is a covered issue, my lord.
Let it go before the other bench. Let the matter be placed before a bench of which one of us, within bracket Sanjay, is not a member. For the petitioner, Mr. Nirmal Kumar Mathur.
Nirmal Kumar Chaudhary, sir.
Chaudhary, and assisted by Mrs. Vani.
Vani Kumari, your lordships.
But only my humble submission is there, my lord. But there is no difficulty possibly if the petition can be heard by this bench. My lord, on this plea that my lord, my honorable Justice Orson has appeared for the department. My lord, on this ground, possibly, my lord, then any matter against the government cannot be heard.
No, but this is a call of the consent, so this is a very, and otherwise also this is a valid reason to recuse. You'll have any other bench to hear the matter. Yes, next case.
Item 21.
All right, obliged.
Obliged.
Mr. Kamil Sonia, Mr. Ram, Mr. Mishra Singh, Moderator.
Today you are supposed to reply.
Yes, your lordship. Yes, your lordship.
My lord, in 2 lines, may I recapitulate what was my submissions last time, your lordship?
Yes, you can do so. We have taken our notes also.
Written notes of argument is there, my lord. Just I will so go through the propositions. I will not take your lordship's time. Just go through the propositions. The declaration filed by me, revised declaration filed by me, is rejected on the ground that against one of the director, a prosecution has been instituted subsequently. That was issue, and by invoking section 9, clause C, the declaration was sought to be rejected. So, my lord, one of the proposition is that the provision, and this is a proposition only, I will not take your lordship time, only to recapitulate. The provision of Direct Tax Vivad Se Vishwas Act 120 is declarant centric. Person under 9C has to be read in the context of declarant under 2C. Page 2, my lord, my written notes, page 2.
Yes.
I am reading again, my lord. The provision of Direct Tax Vivad Se Vishwas Act 120 is declarant centric. person under 9C has to be read in the context of declarant under 2C. The law, company and its director are separate and legal entities. Section 9C can be invoked if prosecution is instituted against the declarant, the petitioner company herein, not his director or any other person. 2. Direct Tax Vivas Act 2020 is a beneficial legislation. Section 9 is exclusion clause. Exclusion clauses of a beneficial legislation must be strictly construed and its benefit must be liberally extended, applying purposive construction. The presumption of no declaration. Section 4.6 draws a presumption of no declaration. I have taken a contention that under the Act there is no power to reject. And I highlighted on the last occasion, my lord, prior to this scheme, there were many schemes that were launched by the government to settle the disputes and to unlock the revenues, but those mainly failed because there is power to reject, and the authorities on one count or other they had rejected. So this time that power rejection is not there, but section 4.6 is there, which draws a legal presumption or legal fiction, creates a legal fiction saying that the presumption of no declaration. It says under certain circumstances, it shall be deemed that no declaration is filed. The presumption of no declaration filed under section 4.6 of the Direct Tax Vivas Act 2020 can be invoked only if twin condition of matter particular, not any particular, being found to be false. There must be finding to that effect in the order and upon due application of mine. Section 4.6 cannot be invoked automatically. The word false requires existence of mens rea. The revised declaration 23/1/2021 relates back to the date of original declaration. The revised declaration is not a fresh declaration. Alternatively, without prejudice, my lord, after passing order under section 5.3, in my case, I filed my original declaration, certificate issued to me. In the declaration, I claimed refund 20 lakh. They demanded 9 lakh. So, to correct that error, the revised declaration was filed, and that contention I have taken that the instance of the we opposed the authorities, and they said that you filed revised declaration, which is not rebutted or that is not controverted in the counter. Ultimately, in the worst case scenario, my lord, after passing under order under 5.3, the designated authority had become functus officio. Hence, the first order dated 21/2021 shall be final and binding. In the worst case, it is held. In that situation, my lord, at least they cannot go back. They cannot say that 9C is invoked against you and that earlier order is revoked. They have not revoked it. In any case, I have to be extended the benefit. Only thing is that whether I am entitled to 20 lakh refund or I am to pay 9 lakh as from my pocket. That is the only thing left. The rejection of revised declaration is in gross violation of natural justice. In their counter also they have said that there is no requirement of giving a hearing or issuing so cause notice. That is the point, my lord. So, my lord, the second one, I said that it is a beneficial legislation and it requires purposive construction. So, my lord, what is the purpose of the act? In the compilation, kindly see, my lord, just one line I will read. Page 16, my lord.
Compilation of judgments.
My lord.
Yes.
Page 16, the act, my lord. The objective of the act. Direct Tax Vivas Act 2020, number 3 of 2020. An act to provide for resolution. The objective is to resolve and not to keep pending. An act to provide for resolution of disputed tax and for matters connected therewith or incidental thereto. Then, my lord, circular of the board. Objective, page 28.
How do you read it as a beneficial legislation?
My lord, kindly see page 28, the circular of the board.
Yes.
Para 3, my lord. The bill has since been passed by the parliament and has also received the assent of the Honorable President of India and has now been enacted as the Direct Tax Vivas Act 2020. The objective of Vivas is to, inter alia, reduce pending income tax litigation, generate timely revenue for the government, and benefit and benefit taxpayer by providing them peace of mind, certainty, and saving on account of time and resources that would otherwise be spent on long drawn and vexatious litigation process. So, my lord, this is a beneficial legislation. The intention is to benefit the SSC also and also for the government. And circular relied upon by my learned sister, that is, my lord, also the first para of that circular relied by my learned sister, circular 21 of 2020.
Yes.
It is in the same line, my lord, with the objective to reduce pending income tax litigation, generate timely revenue for the government, and benefit taxpayer by providing them peace of mind, certainty, and saving on account of time and resources that would otherwise be spent on long drawn and vexatious litigation process. The Direct Tax Vivad Se Vishwas Act 2020 was enacted on 17 March 2020. And my lord, the word declarant may be seen in the thick comparison, my lord. Page 17.
Page 7. That you have
Thick
shown in the
comparison, my lord. Comparison, page 17.
Yes, yes.
I am reading section
And
2,
you
my
had
lord. Section 2.
You had shown the judgment of the Supreme Court, delivered by perhaps Justice Sinha.
Yes, yes, my lord.
Declarant and person